Section 5, which is the preclearance requirement, the part that says any state that's covered by the law has to get federal permission before it makes any changes in its election law, or possibly, as long as we're getting all technical, Section 4, which sets out the formula, which says which parts of the country are covered by the law. Let's remember the constitutional part of this. The Constitution gives the states basically the decision to run their own elections. So what Congress has said here is that the states had such a problem, were so discriminatory, that the federal government should override what's normally the state's prerogative. So the question now is the problem still serious enough, A, and does the law cover the areas where the problem is the most serious? Now, what several members of the court said today, notably the foremost liberal, it may not be perfect, but it's a pretty good fit. If you look at where the problems persist, where lawsuits tend to be most successful to try to attack voting changes as racially discriminatory, it's a pretty good fit with the coverage areas now. But the conservatives on the court said, yes, but the problem is that you've got areas in the South that do a better job at registering black voters, getting black candidates elected, having white voters vote for black candidates, a better job of that than some parts in the North. The Chief Justice brought up repeatedly that Massachusetts has a more serious problem with this than many parts of the South. So based on all that, what's going to happen? I think it's pretty safe to say that there are at least 5 votes to strike down either one or both parts of the Voting Rights Act, either the coverage formula or preclearance totally. And let's think about what would happen if that was the case. If the Supreme Court says, okay, the preclearance thing is fine in theory, but we're going to throw out the coverage map, send it back to Congress. The question now is, would Congress have the political will to redraw the maps and do basically what it did in 1965 all over again, and sit down and say, okay, let's look at which states are doing a good job, which states are doing a bad job.
Pete, let me ask you,
and I can't answer that question.
Let me ask you this question. Representative John Lewis, who of course has been long involved in the civil rights struggle, has an op-ed in the Washington Post today, and he points out some very important facts, which is to say, while the 16 jurisdictions affected by Section 5 represent only 25% of the nation's population, they still represent more than 80% of the lawsuits proving cases of voter discrimination. Did that come up at all today?
Yes, those statistics were cited, and that's the supporters of the Voting Rights Act. The 4 liberal justices say that's the reason that it's a close enough fit. Let me bring up one other point, because there was something that one of the justices said today that I think we're going to hear echoes of for many days to come. And it came from Justice Scalia, who is clearly an opponent of the Voting Rights Act based on what he said today, and at least in extending the most recent extension by Congress. He said, look at the votes in the Senate when this has been renewed. The first time it was contentious. Every time it's been renewed since then, most recently in 2006, fewer people have voted against it, to the point that it was 98-0 the last time. Why is that, he said? And what he said is, I think it can be attributed to the perpetuation of racial entitlement, that it's very difficult to get away from that in the normal political process. In other words, he's saying, you can't trust Congress, once it gives the Voting Rights Act remedy, to ever say that the time has come to take it away. But I think it's fair to say, and we're already hearing it down here at the court, that his phrase, the perpetuation of racial entitlement, is going to be somewhat controversial. But back to the vote today, the 2 justices we were watching that were the most critical, we could assume Justice Scalia was going to oppose this based on what they said 4 years ago in a similar case. We were watching most closely Justice Kennedy and Justice Roberts. Everything Justice Kennedy said today seemed to be hostile to the idea that the coverage formula was the right one to keep. And what several of the justices said today is the problem with the law now is that it's reverse engineered. It's fundamentally backward looking, and it isn't forward looking enough. It doesn't have its pulse enough on where the problems still are. So that's why I say I think there are 5 votes on the court to modify the Voting Rights Act in some way that would be a very serious blow to it.
Thank you to NBC's Pete Williams. Joining us now from New Orleans is Marc Morial, President and CEO of the National Urban League.